justifiable self-defense and excusable self-defense. What's the difference between those two things?
So let's say you were approached by somebody with a weapon. You are justified in disarming them or, in fact, making sure physically that they are no longer a threat. But you can't cause the problem and then expect to use violence.
If you're being verbally threatened, is that enough to claim self-defense?
It is not. A verbal threat alone is not enough. You have to show that some action is going to be undertaken. One in particular, a case where the alleged victim was unarmed, but we believed, and we presented it to the jury, that he was going to attempt to disarm the defendant, who was my client at the time, which is a very dangerous situation. And so a person has to make a very calculated decision on almost a second or milliseconds notice.
Hi, I'm Ken Suddith, and welcome to another edition of Legal Lions. Today, I'm with my friend, attorney Chad Dorsk, and we're going to be talking about an issue that is really kind of interesting and misunderstood. So we'll get more into that in a minute, but it's self-defense in the state of Virginia specifically, but could apply to you wherever you are if you're watching this podcast. So, Chad, first, welcome.
Thank you.
And tell us a little bit about yourself, what you do, and then we'll touch on today's topic a bit.
Sure. Approximately 20 years doing criminal defense, federal and state. I have an office in downtown Norfolk, right in the Freemason neighborhood, and I handle a lot of cases from first-degree murder to drug distribution to sexual assault crimes, and so on and so forth.
Gotcha. So understanding self-defense is, we'll start with that. The reason why it's misunderstood, I think, is people assume that they have the right to defend themselves. They're in a situation. What is the biggest misconception you would say people have about self-defense laws in Virginia specifically?
Maybe the biggest misconception is that there's a bright line rule. It's really a case of self-defense is really a case of practicality. And the way that I would describe a legal self-defense would be that under the circumstances, the reasonable person would act in a certain way to defend themselves or others from harm.
Well, that's the next question I have. So what does the law mean exactly when it says force must be reasonable and proportional to the threat? Can you give us maybe some examples so we understand that better?
Well, that's interesting. And all I can do is provide anecdotes and examples of things that
Sure.
I've observed and trying different cases. The one thing that you always want is a client that looks innocent and feels innocent in the eyes of the jury. The jury comes in off the street. They don't know anything about the case, who I am as a defense lawyer, the prosecutor. There's a colloquy at the beginning of every jury trial in which you exclude jurors who know the parties involved or know anything in particular about the case. And they sit down, and for the first time during those 1 or 2 days, they're hearing the information and seeing the images and hearing from people for the first time. And so when your client has a good and positive demeanor, they smile appropriately, they're relaxed, and especially when they have the trust of their defense counsel, the team of the defense counsel and the defendant can really do almost anything. So I would kind of throw the rules out the window, because I've handled and one in particular, a case where the alleged victim was unarmed, but we believed, and we presented it to the jury, that he was going to attempt to disarm the defendant, who was my client at the time, which is a very dangerous situation. And so a person has to make a very calculated decision on almost a second or milliseconds notice. So it's really hard to know in the moment whether or not you're doing the right thing, because most people just act instinctually.
Well, let me ask you this. On your website, it discusses justifiable self-defense and excusable self-defense. What's the difference between those two things?
Well, justifiable self-defense would be if you didn't cause the problem in the first place. So let's say you were approached by somebody with a weapon. You are justified in disarming them or, in fact, making sure physically that they are no longer a threat to you. And excusable would be If you caused the problem in the first place, but you try to retreat as far as possible, but there are no other options of escape, then you can defend yourself in that moment. But you can't cause the problem and then expect to use violence.
Let's talk about something for a second that I hear from friends. I see it all the time. That comes up frequently, and that's road rage. So if someone approaches your vehicle aggressively, when does self-defense become justifiable in a situation like that? They're approaching your vehicle.
If somebody is approaching your vehicle on the highway or on a street,
yes,
I suppose when the situation becomes so dangerous that defense, maybe if you have a weapon in your vehicle, to employ the weapon. Maybe to shoot the tire out or something to that effect.
I was thinking in terms of, especially in our area where there's so much, construction at the tunnel, and they're sitting there, and someone gets out of their vehicle and they approach yours aggressively.
Oh, interesting.
In your vehicle, you have nowhere you can go.
Interesting. I actually handled a case exactly like that recently in Norfolk Traffic Court, in which my client was cut off by another driver. Traffic was moving very slowly. He got out just to walk up to the driver's side of the door and say, "You cut me off." He began to walk back to his vehicle, and the driver got out and started a physical conflict in which both parties were charged criminally.
Well, with that being said, many fights start with words first. People are yelling at each other, however they're handling that. But if you're being verbally threatened, is that enough to claim self-defense?
It is not. A verbal threat alone is not enough. You have to show that some action is going to be undertaken.
So basically, if they push you first, at that point, they've put their hands on you, they've pushed you. What rights do you have? Do you have the right to actually punch them in the back?
If somebody physically touches you, you can act defensively, or if you believe they're going to act physically against you. For example, if they have a weapon and they brandish it, they show the weapon. Let's say they raise a fist. Let's say they move aggressively in your general direction. You can act appropriately.
So obviously, that turns into sort of an assault case. How frequently do you see people charged with assault when they genuinely believe that they were defending themselves?
It typically comes down to who calls the police first.
Really?
And it's really hard to know. I mean, if, let's say, for example, you believe you were acting justifiably in defending yourself, and a criminal charge is taken against you, you can always go down to a magistrate and take out your own charge against the other party. That's the recourse. So
what would you say what evidence tends to make or break a defense case? Evidence like witnesses, of course, surveillance video, text messages. You just mentioned a 911 call and who calls first. How do these play into this situation?
Yes. Eyewitnesses, ring cams, surveillance cameras, text messages, phone recordings. Sometimes the other party is recording the individual that they're trying to entrap into a criminal charge. Maybe they're trying to egg them on, and text messages, recordings, Facebook postings.
Okay, so let me kind of turn to defending your home, because I think many people have heard of the castle doctrine. What rights do Virginians actually have when someone enters their home?
Okay, so the difference between a typical self-defense situation and one in which you're in your home, you have no duty to retreat once you're inside your home. Your home is your castle, and you can defend it appropriately, but you cannot use lethal force to defend property. You can only use that to defend yourself or another human being.
Do you have a duty, if someone's threatening you, do you have a duty to retreat inside your own home? If that's available to you,
if circumstances permit that you are able to, in fact, retreat safely, that would probably be the wisest option.
All right. Well, let me turn to a specific case, if I may. This was sort of a high-profile case, the Marquise Thompson case that you handled. Your office secured a not guilty verdict in this high-profile murder case by arguing self-defense. Without getting into sort of privileged details, what made this case so significant?
I think what made the case significant is I had an eyewitness in addition to the defendant who testified in that case, that it was imperative that the defendant use justifiable self-defense under that circumstance. And I think that made all the difference, especially because the defendant and the witness were both earnest in what they said and showed proper emotion.
So what can an everyday citizen learn from cases just like that, how self-defense claims are evaluated?
I think what the average person can learn if they end up becoming a defendant in that situation is, number one, it requires patience and it requires you to trust your counsel. That case took 3 years to come to trial because it occurred during COVID. And so there were a lot of delays and witness issues that we encountered. So you trust your counsel, you trust your strategy, and you're going to lay it all out there for the jury to hear. And the truth rings clear.
Okay, well, let's say, hopefully not, but let's say someone is involved in an incident where they acted in self-defense. What are the first few things that they should do, and what mistakes should they avoid?
Number one is don't destroy evidence. If you act in self-defense, call the police, call your family. Be prepared to speak to investigators and preserve any evidence that would be necessary to ensure your own defense.
So anything else that we didn't cover that you think is particularly important in self-defense cases, particularly in Virginia, but viewers may be watching this podcast elsewhere, but what would you...
I would say if you own a firearm, be responsible, be deliberate, and be conservative with how you use it.
So self-defense cases, as we talked about, can be incredibly fact-specific, and a single statement made to police can dramatically affect your defense. Would you agree with that?
I would definitely
overview?
agree.
So if you're facing assault, battery, or any criminal charges like this, contact your office. Can you kind of tell us how the best way to contact you if they've been in a situation like this? How should they get in touch?
Call the office, Dorsk Law, 757-423-0271. And just remember, if you encounter a situation where you have used self-defense, make sure you contact an attorney to be present for any statements that you make to law enforcement.
Okay, so call first.
Call first.
Okay, gotcha. All right, well, thank you very much. This has been very helpful, interesting topic. And if you have an interesting topic or things that you'd like to see out there, please let me know. This has been another edition of Legal Lions.